May it please the court. My name is Morgan McPheeters, and I'm here this morning with my co-counsel, Mr. Tanner Franklin, and we represent the appellant in this case, Trooper Sykes, who was a trooper with the Texas Department of Public Safety who filed claims under the Texas Whistleblower Act, and his claims were dismissed on summary judgment. We also represent three other DPS troopers, Troopers Mahan, Riggins, and Barton, whose claims under the Act proceeded to trial and resulted in a jury verdict in their favor. There are essentially three big issues before the court today. The first one being whether the court has jurisdiction to consider DPS's cross appeal as to the jury verdict. The second one being whether the troopers properly initiated a grievance or appeal action, which is a prerequisite to file suit under the Whistleblower Act. And then the third big issue is DPS challenges the legal sufficiency of the verdict as to just Trooper Barton's claims and whether they were, whether his adverse personnel action was a result of his whistleblowing. But it's telling that that's really the only legal sufficiency point that they have raised to attack the jury's verdict here. I think this shows that they know that DPS retaliated against these troopers. They don't dispute the damages that were awarded by the jury. Instead, they are simply attacking the verdict based on a hyper-technical reading of this remedial statute, which is meant to be interpreted liberally in favor of the troopers here. And really, the overarching question before the court today, in a couple different contexts, is whether various parties at certain points properly initiated an appeal, whether that's in the context of the troopers under the Whistleblower Act, or whether it's DPS failing to file their notice of appeal. I'm up here arguing first this morning because Trooper Sykes was the first to file a notice of appeal in this case, and he was actually the only party to file a notice of appeal timely in this case. It's ironic that DPS wants to undo this jury verdict based on their interpretation of the Whistleblower Act and their interpretation that the troopers failed to properly initiate any grievance or appeal, when they wholly failed to initiate their own cross appeal in this case. So while they're asking for a super technical magic words reading of the Whistleblower Act, at the same time, they want leniency in their own assertion of an appeal and whether their emergency motion to stay constituted a notice of appeal. What's key is the fact that Texas courts interpreting the Whistleblower Act have said when it's unclear what a particular agency's grievance policies are, we need to err on the side of the complainant and certainly not read that against them if they fail to maybe particularly comply with some policy. If there's not a policy that's so set out so specifically, we err on their side, and we err on the side of finding that the court has jurisdiction to consider their claims. Federal Rule of Civil Procedure, or Appellate Procedure, 3 is not so unclear. It sets out exactly what DPS was required to put in their notice of appeal in order to grant this court jurisdiction to consider their appeal. That timely filing of a notice of appeal is a jurisdictional requirement. The purpose of that requirement is to give the parties and the court fair notice that a particular order or judgment is being appealed. Here, DPS filed an emergency motion to stay, and they realized later that they had blown their notice of appeal deadline, and then tried to argue, no, actually that motion to stay constituted our notice of appeal. But that motion failed to state which judgment or order they were appealing, and it actually did not assert that they were appealing. The key language in there that they point to actually only says that they intend to file a notice of appeal. So they intended at some later date, apparently, to file a notice of appeal. That is not the same as noticing an appeal. The case that we've cited in our briefing on that point is the Coletta case. It is an unpublished opinion from this court, but I think that language is analogous that the court considered in that case. There were some pro se litigants who filed a motion for extension to file their notice of appeal. The language there was that they were seeking, quote, additional time to appeal the denial of a motion. This court concluded that they never actually asserted that they were appealing. Rather, they just were saying that they intended to at some point. That's the same thing we have here. We have just a statement that DPS intended at some later date to appeal. So for that reason, that this court can dispose of the entire cross appeal for just lack of jurisdiction over it. Turning back to the substance here, with regard to the troopers whose claims went to trial, Troopers Riggins and Mahan unquestionably properly initiated a grievance within the meaning of the Whistleblower Act and within the meaning of the DPS employee policy manuals. DPS agrees that the February 8th, 2019 letter from the trooper's attorney that was sent directly to the dispute resolution chief officer, Kevin Meade, unquestionably initiated a grievance. This is, in fact, one of the informal options that's listed under the DPS policy manual. DPS just argues, though, that with regard to Riggins and Mahan, who their adverse personnel action that went to the jury trial was that they were later transferred to undesirable locations that made it really difficult to commute to work, kept them away from their families, that this was the retaliatory act against them for their whistleblowing. So DPS says, well, because that happened later, that can't possibly count as initiating an appeal under the Whistleblower Act. And what DPS wants is for these troopers at every step of the way, every single time there's some new act of retaliation, some new act of abuse, which the evidence at trial showed was happening really all the way through. Even at summary judgment, the district court noted that there's still acts that are happening in retaliation. DPS wants these troopers to have to restart the clock, redo the grievance procedure every single time something happens, when in fact the retaliation that comes after this February 2019 letter is simply a continuation and an escalation of that same hostile work environment, the same abuse from Sergeant Shugart. But even if that's not the case, even if a prior initiation of a grievance can't qualify to satisfy the prerequisite under the Act, there's a second reason that Troopers Riggins and Mahan still properly initiated their appeal, and that's because reporting that transfer, the retaliatory transfer, to the Office of Inspector General within DPS was also sufficient to count as initiating an appeal or a grievance. While the OIG and Lieutenant Lopez are investigating really this entire overarching hostile work environment, Troopers Mahan and Riggins immediately call him and notify him, hey, we have been retaliated against in this specific way. We've been transferred to this other location. We think this is retaliation. So they assert that grievance. The evidence at trial shows that the Office of the Inspector General and DPS are in communication constantly. So this idea that the OIG is somehow completely separate, that any investigation done by the OIG really can't result in any dispute resolution, has nothing to do with DPS, is simply just not played out by the evidence. And when we look at the language of the DPS policy manual, it doesn't mention the Office of Inspector General. It doesn't say that that can't be a method for dispute resolution. And in fact, what the manual says is it defines dispute resolution to mean any strategy or method used to resolve grievances. And then it says including but not limited to, and it lists some options. But here we have a policy manual that tells these troopers dispute resolution can be anything, any strategy, any method. And then they give examples. It could be consulting with a dispute resolution officer. It can be conflict coaching, chain of command review, which is one of the formal ways to initiate agreements, facilitation, and mediation. But those are just examples. They're not limited to that by any means. And what we have in the record at trial is that virtually every level of the chain of command within the Department of Public Safety agrees that these troopers could report these grievances, the retaliation, the illegal quota system, to the OIG, all the way up to the director. And there's simply no evidence offered by DPS to show that that was not an option. So as they rely on cases that in other contexts have found that reporting to an OIG didn't count, those cases involved instances where there was evidence different from here, that was not an option to assert agreements. Whereas here we have this manual that is really not a model of clarity, but its plain language is very broad, very open. So no question that Riggins and Mahan both initiated that grievance procedure. And the same thing goes for Barton. And finding that these troopers all properly satisfied the Act's prerequisites supports the purpose of this whistleblower statute. The whole purpose is to prevent our government agencies from retaliating against employees who do the right thing, come forward and report violations of the law. And so it's designed to provide them a remedy when they are retaliated against. It's a remedial statute. We're supposed to construe it liberally in their favor. And again, courts have said where there's a question about whether or not someone has complied with a grievance procedure, we ought to err in their favor. Barton, just very quickly, Barton was another one of the troopers whose claims went to trial. Again, the February 2019 letter DPS concedes was an initiation of a grievance procedure. Barton's adverse employment action happened before that letter. It happened in January, then the letter came in February. DPS, with regard to Barton, claims that, well, the letter doesn't specifically say that you were denied approval to apply for this crisis negotiation unit. And therefore, because you don't use the magic words, it doesn't count. But again, for the same reasons, this letter gave DPS fair notice. There's really no question, looking at this record at trial, that everyone within the department knew what was happening. They knew who was complaining. They knew what the issues were. They knew everything that was happening with the OIG investigation. They had their own investigations going. There's really nothing to show that, DPS didn't have fair notice. How could we have resolved this? We didn't know what the problem was. They absolutely knew what the problem was. And to the extent that there's any confusion about whether the February 2019 letter specifically grieved Barton's CNU application, that's completely wrapped up with then he specifically reports that same grievance to Lieutenant Lopez, who's doing the OIG investigation. So if there's any confusion about what his particular grievance was, that eliminated that question. I see that I am just about out of time, so if the court has no questions for me, I will reserve the rest.
I do. As of today, what is your position with respect to the district court entering sua sponte, amending its final judgment under Federal Civil Procedure 68 for certain equitable relief? I don't believe you've mentioned it in your discussion today.
Yes, Your Honor. Our position is that the district court was well within his discretion to do that.
Even though he did not identify he identified completely different rules in his order than what you're arguing?
Well, he stated Rule 60 as his basis, which allows him to modify for where he's intended to include something and then it's simply omitted by mistake, which the evidence from the hearing shows that that's exactly what happened. At the same time, the troopers had also filed a separate motion under 59E, which I think there's no question that would have allowed him to do exactly what he did.
However, the district court makes no reference to 59E after considering the 59E motion, the response, and the oral argument. Do you have anything further to say on that point?
The district court denied the 59E motion as just being moot. So I don't think that there's anything to suggest that the district court did a substantive analysis of that. I think that the court believed that under Rule 60, that gave him the same authority to make those changes. So I think that
So are you arguing this court should speculate beyond the plain language of the district court's amended final judgment?
No, I think that Rule 60 gives him the authority to do what he did. And to the extent that if Rule 60 doesn't go quite that far, the fact that Rule 59 was presented as an additional ground to do that, I think allows the district court to do what he did. And I don't think that it shows an abuse of discretion to have stated Rule 60 if this court were to determine that that's not exactly what Rule 60 allows, when we know 59 would permit it, and it was also raised.
So, just so I'm following you, you're saying, in my opinion, conceding that Rule 60 doesn't your words, I think, exactly allow him to do what he did, but because you argued and the district court considered 59E, this court should go back to 59E and not rely on the specific plain language in the judgment.
Not quite, Your Honor.
Okay, so help me understand, because I'm confused.
Sure. So our position is that Rule 60 does permit exactly what happened here. It is designed to fix clerical mistakes or oversight. And the case law says to figure out if there was a clerical mistake or just an oversight, we look for evidence that the judge intended to include something and then simply failed to do so. And that's what we have here. At the hearing, the judge essentially says, I meant to include this and I forgot. And it was supposed to be in there. No question, this type of relief is allowed by the statute. The plaintiffs had pled it. He just simply meant to include it and didn't. And so that's exactly what Rule 60 allows. But I think that if the court were to determine, no, that's not what Rule 60 allows, I do think the fact that the plaintiffs had raised it as an additional ground, I think that this court could still affirm the amended final judgment because it was raised and would also permit.
Do you have any authority on that? If we find 60A is not applicable?
I don't, Your Honor. And perhaps what could happen, though, is because the district court didn't consider that point, didn't consider Rule 59 and just simply denied it as moot, I would think then the district court should be given the opportunity to consider under 59 and enter it.
What's your best case supporting that this is clerical as opposed to substantive?
One of the cases that we cited in our briefing was the Chavez versus Balesh case from this court from 1983. And in that case, the district court had inadvertently omitted an entire element of damages, the liquidated damages. And in looking at the evidence, the record showed that the judge had intended to award that, and it was simply just omitted, which is essentially the same thing that happened here. He intended to enter a ruling on the equitable relief and just forgot.
Was it done sua sponte in that case?
You know what? I don't know, Your Honor. I'm not sure.
Okay.
If there are no further questions, I will reserve remaining time for rebuttal if I do have any remaining time. Thank you.
May it please the court. My name is Benjamin Dower. I represent the three appellees as well as the Department of Public Safety as cross-appellant. Appellees ask the court to affirm the district court order granting the defendant's motion for summary judgment as to appellant Sykes, and cross-appellant DPS asks the court to reverse the district court order denying its renewed judgment as a matter of law. The primary issue in both Mr. Sykes' appeal as well as DPS's cross appeal is whether or not the plaintiffs properly grieved under DPS policy. And we respectfully submit that the evidence, both in the summary judgment context as well as at trial, reveals that none of the plaintiffs met the requirements of the Whistleblower Act. Now, the Texas Supreme Court holds that a would-be plaintiff under the Whistleblower Act must strictly abide by its procedural limitations to obtain relief. Strictly abide. And so I respectfully submit that what my friend on the other side characterizes as hyper-technical is not hyper-technical. It's strictly abiding by it. And one of those procedural requirements is that the plaintiff must initiate action under the employer's grievance or appeal procedures before suing. Now, this provision has sort of three, I don't know if I'd call them elements, but three requirements. First, the grievance or appeal procedure must be initiated by the plaintiff, the person suing. Second, it must be under the employer's grievance or appeal procedures. And third, it must relate to the adverse personnel action. All three of those requirements must be met. And here, none of the plaintiffs either submitted a grievance or an appeal that meets all three criteria before suing as it relates to the adverse personnel actions that they're suing about and for the trial plaintiffs that went to trial. Now, it's not unclear here what DPS's grievance policy is. It's found in the record in the summary judgment context on page 315 to 321, and in the trial record, it's found at 3445 to 3448, and it's an excerpt from the Department of Public Safety General Policy Manual. Now, that identifies two informal avenues and two formal procedures for grieving. And the Dispute Resolution Office plays a role in all four. And none of the plaintiffs in this case used one of those grievance procedures as it relates to the adverse personnel action that for the trial plaintiffs that went to trial and for Mr. Sykes that he raised in the live pleading as of when his claims were dismissed. Now, focusing first on Mr. Sykes, he fails all three requirements. He did not initiate a grievance or an appeal because he merely participated in the Office of Inspector General investigation into someone else's complaint. And under the case law as regards to Whistleblower Act claims, the grievance must be initiated by the plaintiff, and that's right there in the statute itself. He didn't initiate anything. He was merely interviewed. It was also not under the employer's procedures because the interview related to the whistleblowing complaint about the quota system, and it was to the Office of Inspector General, which, as I'll talk about in a minute, is not part of the grievance procedures of DPS. It's a law enforcement authority, the sort of law enforcement authority who watches and enforces the law as to other law enforcement authorities, such as the Department of Public Safety. And then also did not relate to the adverse personnel action that he sued about. And you can see this right in the language of the Second Amendment complaint. When it's talking about the retaliation for Mr. Sykes, it starts that section by saying after he had spoken to OIG Lopez, who is the OIG investigator. And so even in the chronology and the pleadings, he's saying that the retaliation that he's suing about happened after the interview that he contends was the grievance. And so I want to take a quick step back and like big picture. So when there's a whistleblower lawsuit, it means that someone blew the whistle, it's alleged that their employer is engaged in some unlawful activity, and then the employer allegedly retaliates, and then they sue about the alleged retaliation. And I think the thing that keeps getting sort of blurred here, and I want to sort of separate and distinguish, is the allegation about the unlawful quota system was the whistleblowing. And so, when the Office of Inspector General is absolutely the right authority to investigate that type of allegation, that there is something illegal happening. But then when the Department of Public Safety allegedly retaliated for Mr. Barton, they allegedly retaliated by, they gave him approval for this crisis negotiation unit, but he didn't know about it. And so he alleged that the failure to CC him on the email was the retaliation. And for Mr. Riggins and Mr. Mahan, the alleged retaliation was them being transferred out of the hostile work environment that they had alleged to other stations. And that occurred after, they blew the whistle to the Office of Inspector General. And now they're trying to say, well, the investigation into the whistleblowing activity was the grievance. And that's just, the Office of Inspector General is not an employer grievance policy. That is who you report serious allegations of misconduct, things that are criminal, things that are allegedly unlawful. That's what their function is. Their function is not to resolve grievances. But returning to my point for Mr. Sykes, his adverse personnel actions occurred after the interview that he alleges was him grieving, which again, he didn't initiate. Now, turning then to the trial plaintiffs, Mr. Barton, he identifies, as we just heard, this February 8th, 2019 letter to the Dispute Resolution Office that 4 of the plaintiffs in this case, there was an attorney who represented all 4. Now, yes, that was initiated by the employee because DPS doesn't dispute that an attorney acting on someone's behalf, is basically the same as them initiating because they're acting as an agent for the principal. And we don't dispute that sending something to the Dispute Resolution Office was under the DPS policies, because that's one of the ways in which you can grieve. But it wasn't related to the adverse personnel action. Nowhere in that letter did it give even a hint that Mr. Barton was contending that something amiss had happened with regards to the crisis unit negotiation application. And the purpose of the exhaustion requirement or grievance requirement is to give the employer notice of a grievance and a chance to resolve it. That's what this court held in the Bro versus City of Garland case, which is cited, I believe, in both parties' briefs. And then there are other cases similarly holding that the notice given to the employer must provide fair notice that the employee desires to appeal or hear grieve the employer's personnel decision, and fair notice of the decision made by the employer from which the employee desires to appeal. That's the Ward versus Lamar University. And I simply submit to the court that if you actually look at the language of the February 8th, 2019 letter, you'd have to be clairvoyant to know that Mr. Barton intended to put DPS on notice that the approval that he received but didn't know he received was in some way retaliatory, or that the crisis unit negotiation position was in any way at issue, which is part of the reason that Mr. Barton never learned that he received the approval. What happened was he sent an email and he requested the approval of his supervisor to apply. And 3 hours and 24 minutes after that email was received, his supervisor sent an email to his superior saying, I recommend that he be approved. And the theory that went to the jury was that his failure to CC or circle back to Mr. Barton was retaliatory. Now, Mr. Barton never raised that with DPS and said, hey, I haven't heard anything back. I guess you guys shot me down. I'm upset about this. And that issue that never went to DPS's attention. DPS did not know that this was an issue. From DPS's perspective, approval to apply had been given, and he just simply didn't apply. And the Whistleblower Act has a very tight turnaround on these things. You have to grieve within 90 days of the adverse personnel action that you're suing about. And so had he followed any of the 4 mechanisms in the general policy manual and said, hey, I'm going to the dispute resolution office and I'm consulting with the dispute resolution officer. I want to do conflict coaching. I want to do a chain of command review or mediation. Had he done any of those things within 90 days, in all likelihood, the misunderstanding would have been resolved. Instead, he contends that when he was interviewed by the Office of Inspector General, he raised it with the Office of Inspector General investigator. But that's simply not a means through which DPS resolves grievances. And this case has very similar facts to the City of Houston versus Cotton case and the City of Houston versus Garcia case, both of which from the Houston Court of Appeals, the 1st and 14th districts respectively, and it's cited in the brief. And in those cases, the appellate courts held that the City of Houston's Office of Inspector General was not a means through which to grieve a City of Houston personnel decision, because their function is to investigate complaints of retaliation, not to resolve employee problems, but to resolve issues for the city. And its function is to investigate, not to adjudicate. And after the investigation, I'm quoting here, the OIG simply reports its findings and conclusions to others. And that's exactly the facts and the evidence in this case, that the Office of Inspector General is there to investigate serious misconduct. It's by statute, Texas Government Code Section 411.251. They independently and objectively review investigating criminal activity, allegations of wrongdoing, crimes committed by the department. They're not there to try to resolve personnel issues like, hey, why didn't you approve my application for this crisis negotiation unit training? Or, hey, this transfer that you're doing to get me out of a hostile work environment that I complained about, I'm actually really unhappy about that, and I don't think it's a good idea. And, when the Office of Inspector General is looking at these things, and I think this is reflected in the report itself, which is found starting in the record at 2770, they're looking at it through the lens, kind of like a lawyer or a criminal investigator. They're thinking, was this actually unlawful? Is what happened a violation of the Whistleblower Act? Is it a crime? They're not thinking about it from the perspective of an employer, like, is this a good idea? Is this a good personnel decision? Is this wise from that perspective? And they're also not in any hurry to report because they want to get it right, and they're thinking about it from the perspective of, was this a crime? They're not thinking about it from the personnel decision standpoint. And so here they took 12 months to actually make their findings. Whereas in the grievance process, we're thinking fast turnaround because the employer has an incentive to resolve the issue, because after all, within 60 days of the employee initiating the grievance process, they can file a lawsuit. And the entire point of having this requirement in the Whistleblower Act is to give the employer an opportunity to resolve the dissatisfaction prior to the employee suing about it. And, I keep going back to Mr. Barton. Had he done that, had he used any of the mechanisms in DPS policy, then the issue probably would have been resolved because it was a misunderstanding. I also want to emphasize that my friend on the other side made the point that the list in the policy uses the word including, suggesting it's not exhaustive. But I would humbly submit to your honors that there's nothing informal about reporting your employer to law enforcement. I mean, to use the example of, if someone's stealing from the cash register, it doesn't help resolve the grievance to report them to the local police. And that's effectively what the Office of Inspector General is. It's law enforcement for law enforcement. It is not part of how DPS resolves, disputes with its employees. And that's why for Mr. Riggins and Mr. Mahan, neither of them exhausted or grieved either. Because while it is true, the evidence showed that they contacted the Office of Inspector General investigator who was reporting or investigating their whistleblower complaint, the alleged unlawful quota system. That's not part of resolving a grievance. Had they initiated any of the means through which DPS policy recognizes in the policy manual, then that would have been a way to grieve those issues and say, hey, I know that my immediate superior said that this was a win-win because it gets me out of the hostile work environment I've reported. But I don't see it that way, because now I'm going to have an hour and an hour commute each way. And while I am being paid for that because it's on the clock, at the end of the day, I'm really unhappy about that. I don't think that's a fair way to resolve this issue. And if they had used the grievance system, any of those four mechanisms, then they could have used the chain of command all the way up to and including the director of DPS to get that perspective to the people that make personnel decisions, rather than the Office of Inspector General, who's focused on, was this a crime or was this a violation of law, not looking at it through the lens of, is this a good idea from a personnel management perspective. I do want to quickly talk about the court's jurisdiction over the cross appeal. The only requirement for what constitutes a de jure notice of appeal is that it has to be filed within the time required by Rule 4 and contain the requirements of Rule 3. And here we met both those requirements. It was filed within 30 days of entry of the judgment. I think it was filed within 4 days, actually. And it gave the notice required because it identified the court to which the appeal was taken, this court. It specified the party or parties taking the appeal, and it designated the amended final judgment as the thing being appealed. My friend on the other side quoted the unpublished case of the Security and Exchange Commission versus Coletta, but that is readily distinguishable, as we do in our ultimate brief in this case, because there the intent to appeal was extremely equivocal. The party failed to state which judgment or order they were appealing, and they only indicated that they needed more time to determine if the issues warranted an appeal. And here, DPS's emergency stay was unequivocal in stating the intent to appeal, that defendant is likely to succeed on the merits of the appeal. There was nothing equivocal, wishy-washy about what was filed. The intent to appeal was clear from the document. And while my friend on the other side emphasizes that, well, that wasn't what they intended, DPS's counsel didn't intend that to function as the notice of appeal. The Supreme Court held in Smith versus Berry that the intent is not really what matters, not the litigant's motivation in filing the document. What matters is, does the document meet the rules? And under Rule 3C, an appeal must not be dismissed for informality of form or title of the notice of appeal. In my remaining few minutes, I do want to touch briefly on the other two issues, the jury's verdict for Mr. Barton. We do ask the court to reverse that verdict because it's no reasonable jury could conclude that Mr. Barton that Mr. Shugart engaged in inaction and or delay with respect to Barton's promotion request, nor could they conclude that that was in some way retaliation. The evidence, as I mentioned earlier, shows that the approval was prompt. It was within 3.5 hours of receiving the email. And so there's no inaction and or delay. I know that at trial, plaintiff's counsel argued, well, the inaction or delay was really him circling back to let Mr. Barton know, I went ahead and recommended you. Respectfully, I think that goes too far afield from the actual language of the jury charge. I don't think that's with respect to the promotion request. But even if it does fall within the scope of the language of the jury charge, we would submit that there's simply no evidence, none, that the failure to CC was in any way motivated by retaliation based on any protected activities in the case.
But didn't the jury consider that argument?
They did, Your Honor.
They rejected it.
They did, but I think in so doing, they necessarily,
What makes it unreasonable? I mean, flipping a jury verdict is a...
No, I know, Your Honor, I know. And that's part of the reason why DPS did not, advance the argument as to Mr. Mahan and Mr. Riggins. I know my friend on the other side made some negative comment about that, as though we can draw inferences that DPS agrees with the verdict, and of course we don't. But I think for Mr. Barton specifically, the evidence that Mr. Shugart issued the approval so quickly, that his superior also approved it, is so strong, and the absence of any sort of direct or even circumstantial evidence regarding a failure to CC being motivated by something, that the juries necessarily relied on speculation in reaching their conclusion. And so while I recognize that it is an extraordinary request, I think the evidence here substantiates it. And I think the case that my friend on the other side relies on, the Bible versus Harris County case, is readily distinguishable because there was lots of circumstantial evidence as it related to the specific personnel action at issue, which was basically that the interview was supposed to last for 30 minutes. They cut the plaintiff off at 4, that the alleged retaliator was rolling their eyes during the interview. All of these things that were related to the specific personnel action at issue, which the jury could have reasonably relied on and to support the verdict. And here we've got just the opposite. The superior being supportive of the request and doing so very quickly, given there was only 2 days left to give the approval. I see that I'm out of time. If you have questions, obviously, I'm happy to entertain them. If not, I'll wrap up. Okay.
Thank you, Counsel.
For all these reasons, we ask the court to affirm the district court order at summary judgment and reverse and render regarding the renewed motion for judgment as a matter of law.
May it please the court. The troopers here tried to do the right thing. They tried to honor the chain of command. They tried to raise these issues within the chain, and the chain betrayed them. It's absolutely reasonable, looking at this record, for them to think, I need to go to the OIG because my chain of command is not taking this seriously, or worse, my chain of command is part of the problem. With regard to Trooper Sykes, he initiated a grievance. His adverse employment actions were his allegation that he was being stalked by his supervisors at his home. They were startling his family. He also alleged that he was denied a request to transfer to a location that would be closer to his family. In the summary judgment record, we see that Sykes met with someone in his chain of command. He met with Captain McDaniel after putting in that transfer request. And he specifically testified that he told her, y'all are retaliating against me for doing this, meaning for speaking out about Shugart and his illegal conduct. He also then, of course, participated in the OIG investigation where those issues were reported and investigated as well. With regard to the comments about the OIG's purpose, that it's not to resolve grievances. My opposing counsel says that the OIG is meant to be a place where you report serious allegations or violations of the law. That's what these gentlemen were doing. This is not just a garden variety personnel HR issue. Hey, I don't like this transfer. I'd like to be transferred somewhere else, that sort of thing. What they're alleging is illegal retaliation. So if the OIG is meant to investigate and resolve disputes and allegations of violations of the law, that's a great place to go. And that's exactly what basically everyone in the chain of command said at trial. With regard to Trooper Barton, the case law says that when we're trying to decide if a particular personnel action was retaliatory and if it was caused by a whistleblowing incident, we are to look at all of the circumstances, and we can consider circumstantial evidence. One of those factors is the failure to abide by previous procedures for employment actions. Barton testified that he had previously asked for chain of command approval, the same type of approval, in the exact same way, and that the way that he got notified that he received that approval was through an email. So this is what he reasonably expected. I think that DPS perhaps tries to minimize this issue by saying, oh, he just wanted to be CC'd on the email. But it's not that. It's that the evidence shows that's exactly what has happened before, and that's exactly what he reasonably expected to see. Not notifying someone that you've given them, or you've technically given them approval, is inaction. And that's exactly what the jury found. Another factor that courts are to consider is whether the stated reason for that employment action is just pretext, right? is the question here is, is Shugart giving technical approval but not ever telling Barton? Is that just pretext as a way to retaliate against him? And if we look in the record, we see that there's evidence that Shugart and Lieutenant Brazil both had tried to deny another trooper, Trooper Ramos, an employment opportunity because he had participated in the complaints against Shugart as well. So taken together with other evidence cited in our brief, that suggests that what was happening here was pretext. Oh, we didn't notify you, but we technically gave you approval. Well, it just really didn't mean anything for them to technically give approval but never tell him. And just lastly, with regard to the DPS policy manual and the grievance procedures, again, that language is so broad. It says including but not limited to. And this cash register example that, it would be, of course, permissible for an employee who is robbed to report it to law enforcement and to do whatever's in the policy manual. That might be true. That might be more applicable here if we didn't have so much evidence in the record that the OIG was precisely a place to report these grievances as these troopers did. So if there's no further questions, we would just ask that the court reverse the summary judgment and affirm the jury verdict and judgment in favor of the troopers in all respects. Thank you.
The court will take a brief recess.